All right.
Now, can everybody see the screen from where we're at? Okay.
Okay.
Go ahead, Mr. Hill.
Thank you, Judge. First and foremost, ladies and gentlemen, I want to thank you. This has been a very long process from day one until today. But I appreciate your service. I appreciate your patience. And I certainly appreciate your attention. You have been very attentive throughout this whole process. There's been a lot of things that we've talked about and that have been presented to you, so thank you very much. The way that I look at juries in the cases I've tried in my career is I really consider juries the heartbeat of the criminal justice system. Because really, without you, the process does not really move. So thank you for that. So let's get right into it. If my iPad decides to cooperate. The first thing we're going to talk about, and I want to just cover some general stuff that the evidence was presented to you. Certainly, the date of this crime was June 29, 2014. The venue of this crime was on Automobile Road, which is here in Muskegon County. And the time was shortly after 6 p.m. And we'll talk about that here in just a second. The elements that I'm required to prove are, in element number 1 is the same for both charges. And that we're talking about first-degree premeditated murder, we're talking about first-degree felony murder. And element number 1 is the same, and it's an important one, that the defendant caused the death of Rebecca Bletch. That is, Rebecca Bletch died as a result of being shot. And we know on June 29, 2014, we know that Rebecca had worked that day at Sanctuary of the Shores. And we know from her coworker, was the first witness that I had testify to you, is that there was really nothing unusual about her demeanor that day, nothing out of the ordinary. In fact, if you recall, she talked about knowing Rebecca to kind of wear her emotions on her sleeve. And if you've ever known anybody that wears their emotions on their sleeve, they usually don't keep those to themselves. And as she indicated, there was nothing that caused any concern for her or that she thought that there was anything wrong. We know that Rebecca came home right around 5:30 as soon as her shift was over, and that she did what she normally did, which was dress up to work out. And her normal workout routine was walking or running Automobile Road. We know that Kenneth Bletch, the relative and the neighbor, actually saw Rebecca in her workout clothes walking down Automobile Road right about that time, right about 5:30. We know that she was alone, and we know that that particular area is very rural. In other words, it's very unpopulated. Houses are very far apart. There isn't certainly a lot of businesses in the residential area. It's really kind of spread out. The other part that's important that we found out for this conversation is that Riley Thompson, that intersection of Automobile and Riley Thompson Road, is only about a quarter of a mile away. We also know that during this time period, the defendant lived at 1842 South Sheridan Drive, and that during this time period, it was just he and his wife living at the house. There was nobody else. We also know that during this time period, the defendant was working third shift at Herman Miller, and if you recall the discussion with the HR person, Ms. Mogenberg, that shift started right around 9:45 p.m. And from her memory and record, she recalls that on that particular Sunday night, the defendant clocked in at 9:45 p.m. We also know that in March of 2013, that the defendant purchased a 2006 silver Dodge Grand Caravan. I think one of the most important things, and it took all the way until yesterday to make that determination, or to hear that determination, is that prior to the defendant testifying in this case, he'd read all the reports, he'd gone through all the transcripts, and certainly he sat through the entire trial. To me, that's a significant piece of evidence. When the court reads the instructions to you, one of the instructions he's going to read to you is what we lawyers call MRE, or Michigan Rules of Evidence 404B, or Other Acts Evidence. It's a specific instruction that allows the prosecution to introduce other acts that either the defendant is charged with or not charged with, but are not necessarily directly related to the case itself. And you'll hear the instruction will tell you that it requires you to use that evidence for specific purposes. So in our conversation this afternoon as it relates to element number one, whether or not the defendant caused the death of Rebecca Bletch, I'm asking you to use that evidence to either help show that he actually did it, in other words, his identity, or a common plan, scheme, or system in doing an act. So keep that in mind as we talk about that. And what I'm talking about is the evidence you heard in relation to Jessica Herringa and MJN. Those are the two pieces of evidence that I'm talking about under that instruction. So I want to start that conversation with what you heard from Specialist Jerry McCarthy from the Computer Crimes Unit. And Jerry McCarthy talked to you about the defendant's, what I call digital life. What does digital life look like? And this was based off of his forensic review of the computer devices found at the defendant's home. Computer towers, the external hard drives, as well as the flash drive. That's what we're talking about. And what Mr. McCarthy told you is that on those external hard drives, what he found were not one or two or three or even 100, but thousands of videos that depicted graphic scenes of abduction, rape, and kill. And what I found somewhat disgusting yesterday is that this was the defendant's outlet. Because he and his wife were not engaged in sexual relations, this was his outlet, I guess, to satisfy his needs. In particular, Mr. McCarthy talked about that film titled The Jogger. And ladies and gentlemen, I chose not to show that for a lot of various reasons. But one of the biggest reasons was that it wasn't worth showing that kind of stuff to you or to have the audience see that kind of stuff. So I had Mr. McCarthy explain it to you. And I hope you got the sense from his explanation of what he had to watch, what he saw in that video, and the striking similarities between that video and what happened to Rebecca Bletch. The fact that there was a woman out in a rural area jogging all by herself. The fact that she was abducted by a male person. That she was dragged to a van. Ultimately disrobed, raped, tortured, and killed. The other thing that Mr. McCarthy talked to you about was the homemade videos that he found on these external hard drives. The secret surveillance, as I classified them, that the defendant readily admitted to yesterday. The neighbor girls, the teenage girls, his neighbors, secretly videotaping them as they undressed in their room. The swim meets, where he focused in on the girls' crotch and buttock areas. And certainly Michelle Snatella, the secret video in the Herman Miller parking lot that he took of her. Now, as Mr. McCarthy told you, each one of those devices had Mr. Willis's kind of digital prints all over them. In other words, there were password documents that had usernames and passwords that the defendant was using. They had the defendant's resume, certainly indications that the defendant was using this. And yesterday, he told you those were his and he was using them. So we start with the VIX file. And this is of particular importance. As Mr. McCarthy explained to you, you had the JLH file and what DZ13 meant. That DZ, if you line it up with the alphabet, meant on 4/26/2013, the exact date of Miss Herringa's disappearance. He also told you that the Rebecca Bletch part of this part, the lower part, was created, along with the VIX file, was created on July 1st, 2014. And of particular importance, certainly, is in the Rebecca Bletch folder, again with that interesting coding on it, 6/29/2014, the day of her death. The images that we displayed that were inside that folder. But the explanation of the defendant yesterday, weeks after Rebecca Bletch is killed, he's getting his phone records and he's squirreling away in this particular file under scans, phone. I can tell you, ladies and gentlemen, I certainly didn't kill Rebecca Bletch. But on June 29, 2014, I didn't go back and get my phone records and put them away just in case I might need them. To me, that's a significant piece of evidence. Significant. I look at this, ladies and gentlemen, as the defendant's digital trophy case. Because VIX is a short version of victims. This was a collection of the defendant's victims, both Jessica Herringa and Rebecca Blatch. The other important thing that Mr. McCarthy told you about is that he scanned these devices and found no indication, no evidence, no inkling of Kevin Bloom whatsoever, if you recall that part of his testimony. Didn't find Kevin Bloom anywhere. That leads us to April 26, 2013, the night that Jessica Herringa goes missing. We know that she was working alone. We know there were no video cameras in the store. We know, what I found interesting too is that the defendant claims that, I didn't know that there were no video cameras, yet he was a frequent customer, if you recall that part of his testimony, a frequent visitor to that particular gas station, which made certainly any employee vulnerable to a lot of things, whether it be armed robbery or what have you. But certainly, in Ms. Herringa's case, it made her really vulnerable as she disappeared that particular night. We know from the evidence that the defendant knows who she is. That, in fact, on April 26, 2013, during the day, around the 5 o'clock p.m. hour, he was there. We know that during the evening hours, he was in the area. That Lang's comic store at the time was in the Center Point Mall area, very close to the Exxon station. That leads us to the testimony of Susan Follett. If you recall her testimony, she actually was an employee of the Exxon station. And that particular night, her and her husband at the time were out for a motorcycle ride. And they happened to be riding past the Exxon station around the time that a silver van made its way to the back of the Exxon station. And as it was making its way to the back, it cut its headlights out, if you recall her testimony. And she further explained to you that where she saw that van, if you remember, they rode by and she saw that. They circled back and ended up sitting in the parking lot. And she described where the van was. That the nose of the van was kind of sticking out from the corner of the building, which left the back of the van very close to that service store that you saw pictures of. And she recalled to you what she remembered from that night. Seeing the hatch of the van open. Remember she talked about the dome light. At the hatch coming down and immediately popping up like something was blocking the lock. And then she recalled to you as that van, as the single male driver got in the van and drove off, and they got behind it, a couple of important things. First, she recalls the driver wearing a red shirt. And we know from the search warrant done on the Willis residence, this is what was classified as the pink room, where Detective Chad Peterson did the searching, talked to you about this photograph, that it was mostly male clothes, if not all male clothes. We heard from the defendant's ex-wife, who said this was kind of her craft room, but the defendant kept his clothes in this room. And we know from this photograph that he owned a red shirt. We do know, too, from Ms. Follett's testimony that as that van passed them, she noticed no movement anywhere else in that van. Nobody in the passenger side. No movement in the back. Other than the driver. We also know, as I showed her these photographs, that she told you that the van she saw that night was consistent with these three photographs. Those photographs just so happen to be the photographs of the defendant's van after it was impounded. And we also know from Ms. Follett that when they got to the end of the service drive, the van turned north on Old Grand Haven Road and they went south. And we know from the other pieces of evidence that that van, as it made its way up Old Grand Haven Road, passed by Boyer Coin. And we also know from the testimony that the most direct route from that mall area to 3038 Bailey is to take Old Grand Haven Road, Seaway to Getty, and right on Bailey. We also know from the testimony of Larry Brooks. Larry Brooks, he was the design engineer from Chrysler, 31 plus years of experience, who went through and talked to you about what he does for a living, how he views cars, and that he had taken that Boyer Coin video and played it backwards and forwards and backwards and forwards. And based on his training experience and expertise, told you that he was 100% sure, that the vehicle in that video was a Dodge Grand Caravan manufactured between the years of 2001 and 2007. And he explained to you, if you recall, he kind of pointed out the features that he saw that made him confident of making that choice. We also know from the crime scene, well, I should say, as we look at the map here showing the direct route from the mall to 3038 Bailey, and we'll talk about 3038 Bailey here in a second, but you folks do know, and I hope remember, the testimony of, in particular, Zach Sparks and even the defendant yesterday. 3038 Bailey was the former residence of the defendant's grandfather, who died in 2011, and nobody really lived in that house from 2011 when the grandfather died until the present, even into the present day. We do know from the crime scene at the Exxon gas station that officers find this Carl Walther laser sight battery cover. We also know from the crime scene, and lab tests confirm, a small little spot of blood that turns out to be the blood of Jessica Herring. We also know from the testimony of Mr. Foster, who indicated that those battery covers they're small, and you saw how small that battery cover was. The amount of force that it would take in order to knock something like that off. So we can presume that Jessica was either knocked out or perhaps made unconscious by a substance like insulin. And we know the defendant had access to that. And we know from the testimony of the ex-wife, and the defendant for that matter, that he was pretty familiar with what insulin was, what it did, the effects that it had on folks. And he certainly had supplies of needles, and he certainly had supplies of insulin. His wife had been a diabetic since 2005 and was getting insulin on a pretty routine basis every 3 to 6 months. We also know that on the inside of that toolbox, there was this injection map indicating on what areas of the body have either a slow reaction speed, a medium speed, or a fast speed on the inside of the toolbox. More importantly, from the testimony of Michelle Schmidt from the crime lab, we know that the battery cover, that the defendant's DNA profile is contained within that mixture, at least to the point where he cannot be excluded as a possible donor. We also heard from Corporal Chris Hare, and we talked about instructions. The judge is going to give you an instruction that talks about how you deal with credibility of witnesses. Because you and you alone are the sole judges of credibility of the witnesses that testified in this case. Some of the things you're going to hear, and I want you to pay very close attention to, is whether or not any of the witnesses had a personal interest in how the case was decided, or whether or not the witnesses had any special reason to lie. And that includes, ladies and gentlemen, the defendant. He became a witness the minute he took the stand. We know from Corporal Hare's testimony that he and Sergeant Baker went to follow up on a tip involving the defendant. They were told that his wife wasn't home and that his cell phone was not there. Corporal Hare was also told that the defendant went to the Exxon station around that 5 o'clock hour, spent some time at that Lang's comic store, was home by about 9:45, and was home until 12:30 a.m. So from 9:45 to 12:30 a.m. the next morning, that Corporal Hare was told by the defendant that he was home. We know that's not true from the testimony of Mr. McDonald, or I should say Sergeant McDonald, that on that particular night at 11:23 p.m., there's a phone call coming from the Willis residence to the defendant's cell phone. And it's bouncing off a tower very near to the Bailey Street address. We also know that another phone call comes in at 11:59 that same night. Again, bouncing off a tower encompassing the Bailey Street address. We know that, as Sergeant McDonald explained to you, this text idea is essentially the phone telling the user, hey, you missed a call. FYI. Again, though, sending that signal bouncing off the tower that encompasses the Bailey Street address. And finally, the defendant calls back to his residence at 12:05 a.m., incorporating, again, the Bailey Street address. Now, I was interested and curious yesterday, and this is going to be kind of a running theme, ladies and gentlemen, this convenience defense, I'm going to call it. Convenience defense of the defendant. Because he had an explanation. I mean, he said Corporal Hare lied, was mistaken, made a mistake or lied, one of the two. That, oh, no, I was out and about at 11:15, 11:20. I went to Grandpa's house. I was looking for some boards to fix my dog crate. So, essentially, the defendant wants you to believe his version that he spent over an hour at the Grandpa's house picking up 5 boards. You have to ask yourself, does that make sense? Given the video evidence of the van, the time frame, remember the time frame of when Jessica went missing. Last seen 10:52. Mr. Harpster comes in at about 11:07 and she's gone. Compare that to the video, compare that to the phone records. The hidden answering machine tape, the message from Corporal Hare asking to speak to Shar. Shar told you, I never got that message. I was never told by the defendant that the police were looking to talk to me. The other theme that I hope you're picking up on is this idea that the defendant likes to keep little trophies. We got the digital trophy of the VIX file, and now he's got this little trophy, this message from Corporal Hare. Because there's 2 messages on it, if you remember. It was the message saying, I want to talk to you, and then it was the message of, hey, you know what, we're kind of going in a different direction, I don't want to talk to you. He saved that. And how do we know he saved that? Because the camera bag where that came in, there was a battery in that bag, and Mr. Hayhurst talked to you about a stain on that battery that matched the DNA profile of the defendant. And there's a 1 in 13 billion chance that it could be somebody else. Also in that, he swabbed the camera bag. If you recall, he swabbed the shoulder portion of that camera bag. And Mr. Hayhurst talked to you about that indicating that the swab of the shoulder strap matched the DNA profile of the defendant, 1 in 4.7 quintillion, which is 18 zeros. The other important thing, the other interesting little trophy or treasure that was found in that camera bag, you learned about this morning. That list of serial killers. 50 or so, I think it was 50 serial killers in the United States. One group marked the toolbox killers. Their claim to fame was abducting women, raping them, torturing them, killing them. Again, put that in the context of everything else that you've heard in this case. The other important thing on the battery and the camera bag is that Kevin Bloom was excluded. His DNA profile is nowhere on them. The other thing that I don't want you to forget about is the bleach bottles. Bleach bottles at 3038 Bailey. And what it was interesting, kind of tied in just a little bit. The defendant told you yesterday that, and we kind of knew this, the grandpa died in 2011, and he either did his laundry or had help doing his laundry up until that point. No laundry was being done, nobody was living in the house. If you remember Sergeant Sparks' testimony on what he did, the manufacturing dates of the Tide and the Clorox bleach, 2013. What do you need that for? Nobody's doing laundry anymore. Well, we know from the lab people how powerful bleach is in eliminating certain things like DNA. Think about that. The other event that I want you to consider is April 16, 2016, MJN. Another theme, young girl, kind of an isolated, desolate area, rural area, by herself. You saw the Blueberry Field video. You saw, the evidence I think shows, almost like stalking behavior. Ben drives north on Weber Road. There's a period of time. Certainly the evidence suggests that that's enough time to reach under your seat, get your gun ready, get your syringe ready, come back southbound on Weber Road, do the kind of turnaround in the Blueberry Field as you all saw. And again, Larry Brooks talked about the fact that, again, in his 31 plus years as an expert in the field of engineering design, he was again 100% certain that that van was a Dodge Grand Caravan 2001 to 2007. We know Larry Brooks is right because the defendant said, "Yep, that's me. That's me." But don't give him any credit for that. He had to admit it. MGN, not only back in May of 2016, picked him out of a photo lineup, identified him in court as the guy that picked her up. He's got no choice but to admit at that point. As I talked about, those rules of credibility, thinking about, does MGN have any reason to not tell the truth? Does she have any reason whatsoever? Any reason at all? And as she told you, the ruse. She really didn't want to ride. All she wanted was to use the phone. You remember her saying that to you? All she wanted to do was use the phone just to call her mom. That's it. Didn't need a ride. Let me use your phone. Defendant tells her, no problem, you can use my phone, but you got to get into my car. This is a 16-year-old girl. She gets into the car. Car takes off. Shortly, during that phone ride, she asks, "Hey, can I use your phone?" And at that point in time, she's told, "Oh, the phone's dead." If the defendant wasn't trying to abduct her, I don't know what other scenario shows that. He could have told her that while she's standing on the road. And as MJN testified to, told you, as they are driving on North Green Creek, he produces a gun. And she describes an orange tip, if you remember correctly. That orange cap. I showed her this picture, and she said, yes, that's what it looked like. And we know from not only the evidence that was collected from the defendant's house, but what Shar told you, that cap protects those plungers. So the needle has an orange protector, and the plunger has an orange protector. We also know she described, and we showed you the exhibit, the black netting between the driver and the passenger seat. This idea that, and as she told you, once that gun was produced, she felt like she had no other option because the car wasn't slowing down, it wasn't stopping. She had to basically save her own life. And thank goodness she did. She jumped out of that moving vehicle at her own peril, ran down the street to the safety of Dawn Schmidt. The defendant's version of this is doesn't fit the evidence at all. The fact that he claims that this particular kit was for emergency purposes, yet he stores it in a locked safe with a gun. The gun and the emergency safety kit ride in the same container. What's interesting is this search warrant is done about a month after the attempted abduction of MJN. And you notice, ladies and gentlemen, notice one of those needles is full. And we know from the FBI lab that that liquid inside that needle is insulin. MJN was going to be victim number 3. Probably the most compelling part of her testimony was that as she jumped from the van and as she ran out of her shoes trying to save her life, and looked back, she saw the defendant with the gun pointed at her. And all she could think about, don't let me die. Don't let me die. And you heard not only from Dawn Schmidt, kind of the hysteria that MJN was under when she ran to her door. And you remember Dawn hear her say, he's got a gun, he's got a gun, he's got a gun. You also heard from Deputy Blackmer when he came on the scene, and he talked about her demeanor, her state of mind. But I think probably the most compelling piece of evidence to really demonstrate how scared, how just utterly out of her mind she was that 911 call. You heard her voice. That wasn't somebody that thought this was a joke. That wasn't somebody who thought that there was something fake about what was going on. That was real fear. Real fear. Not having a cell phone offered to you, that doesn't cause a little 16-year-old girl to act like that. No way. No way. And the other important piece of evidence that strongly suggests that we're talking about a handgun here, what do deputy and detectives find at the scene? 2 live rounds. 22 long rifle, CCI brand. That is not a coincidence, ladies and gentlemen. There is no coincidence. There is no, those bullets were there. They probably were there for years, and the defendant just happened to pick the wrong spot to have her jump out of. No way. No way. Again, viewing the entire case in its entirety, there is no way. MJN is alive today based on divine intervention and probably a nervous defendant and a faulty weapon at that moment in time. Otherwise, she suffers the same fate as Rebecca Bletch and Jessica Merrick. I am absolutely, and the evidence convinces me of that. That leads us to the interview of the defendant. He's asked, What'd you do that day? I was at home all day. Lied. Now, maybe I went to the tractor supply place. Lied. And the defendant told you yesterday he did that on purpose. He knew exactly what he was doing that day. He knew he was involved in that day. But he lied to the officers, to the detectives. This wasn't an innocent encounter. No way. The facts and circumstances do not add up to an innocent encounter. Not a chance. Not a chance. The evidence supports MJN's testimony. Let's talk about that gateway computer for a minute. The defendant's statements yesterday indicating he never used that computer. Again, it doesn't support the rest of the evidence in this case. As Mr. McCarthy told you, as he did some forensic reviewing, and he had to recover some of this stuff because it was deleted. Remember that. That's kind of important. That what he testified to finding on that computer had been deleted, and he had to recover it. But we have in 2012 the Amazon and Google searches for holsters and silencers, looking for things that fit Walther's. And I think, certainly the 2013. So we went from Amazon and Google general searches directly to Walther Arms in 2013. In fact, more specifically, if you recall, April 1st of 2013. And this, ladies and gentlemen, coincides with the defendant's possession of Michelle Snotella's gun. If you remember from her testimony, she bought that gun, and we certainly have the records to show that on May 1st, 2012, she bought a Walther P22 pistol equipped with a laser sight. The defendant readily admits that she told you they had conversations at work about this gun. So he knew that she had this gun in her possession. As Ms. Snotella told you, she last saw that weapon on the end of February 2013. It was the last time she saw it. If you recall, her husband had a friend over. They kind of brought out the show and tell, I guess, version of that, brought it out. That was the last time she saw it. The other important piece of evidence here is from Ms. Mogenberg, who indicated, and Ms. Snotella testified, that in the early part of March, she remembered an event where the defendant was on vacation and she was working. She came home, saw snowmobile tracks, and had a conversation with him about those snowmobile tracks. And he said, yeah, I was around your house. The records are in evidence. In fact, that first week of March, Ms. Snotella is working. The defendant is on vacation. We know from her testimony that she doesn't lock her house unless she's going out of town. If she's going to work or whatnot, she doesn't lock her house. We know that at the time she was storing her weapon in her bedroom, in her closet, and in that same room was where her dirty laundry basket was. Certainly that becomes important when we were talking about these pairs of underwear. And let's remember that for just a second. That these underwear were not found in the defendant's house. They were found in a shed, in a plastic bag, wrapped in tinfoil, kind of tucked and hidden in the rafters. They were ID'd in court by Ms. Snotella. Said, yep, those are my underwear. And we know from David Hayhurst, the forensic work that he did, where he swabbed the waistband of the red pair and had some stains to work with in the pink pair. In the red pair, we know that there was a mixture of profiles that contained the DNA profile of the defendant and Michelle. And we know from the stain, part of that stain was actually semen and sperm. And we know that the DNA profiles of both Michelle, and certainly the DNA profiles of both Michelle and the defendant appear on that pink pair. In particular, the semen stain connecting to the DNA profile of the defendant. And as it relates to Kevin Bloom, he's excluded. His profile does not appear in any of those mixtures. So let's talk about this P22. Oh, I should mention, we talk about CCI brand. As you folks know, in the search of the van, officers find inside the toolbox, inside this second locked box, a box of 22 long rifle CCI brand ammunition. Now we know from the handgun found, this P22, that when it's recovered, the serial number of that gun is obliterated. And if you recall seeing those photographs, it was kind of a close-up, and that serial number, all it looked like was a piece of metal. And Lieutenant Crump talked to you about the methods they use in order to try and restore that serial number, and he also talked to you about some gun manufacturers even have secondary serial numbers hidden on the gun to avoid this particular process. Because, as it was told to you, the reason why, and this is common sense, the reason why you obliterate the serial numbers is to try to make a gun untraceable. And we know from Lieutenant Crump's work that the serial number of that gun matches the gun store records, indicating that that is Michelle Snotella's handgun. We also know some things about this gun as it relates to the DNA work done. We know that David Hayhurst, if you recall, David Hayhurst found a stain on the end of the muzzle. And that stain, when he did his DNA work, the major donor of that stain matches the DNA profile of the defendant. And the chances of finding somebody in the random population of the same profile is 1 in 1.9 quadrillion. That's 15 zeros. And I had asked Mr. Hayhurst this question. The Earth's population is 7.5 billion, which is 11 zeros. We also know from this particular exhibit that there was a stain found on the inside of the barrel. In other words, the part of the barrel that's covered up by the slide. So on the inside part, Mr. Hayhurst told you I found the stain and I swabbed it. And that the major donor of that stain matches the DNA profile of the defendant, 1 in 192 septillion. That's 24 zeros. We also know that Mr. Hayhurst, and again, if you think about it from a common sense standpoint, where are we going to take swabs from where somebody might touch a gun? Well, the most logical place is the grip of the trigger. Your hand, when you grip a gun, you're gripping the handle and you're gripping the trigger every time. So he swabs the handle, the handle and the trigger. And in his work, he finds the defendant's DNA profile matching, and that the chance of finding a random individual in the population whose profile would fit in there is 1 in 6.1 septillion. That's 24 zeros. Now, I go back to the convenience defense. So, defendant gets up yesterday and he tells you, wow, hey, yeah, Michelle sold me that gun. And she gave me a pair of underwear, the deal. I don't know, I've never heard of a transaction like that. And, oh, by the way, in May of 2014, my cousin, Kevin Bloom, really wants to borrow that gun. So I give it to him. And in July of 2014, he returns that gun to me. Oh, and he throws in some gloves. So he gets a pair of underwear from Michelle, and he gets some gloves from his cousin. Right? That's his story. Conveniently, June, he doesn't have the gun. How could he commit the crime of killing Rebecca Blash? His cousin's got it. Problem is, that story is not supported by any piece of evidence in this case. Not one. First and foremost, as he admitted, and as Detective Schultz told you, when they talked to him, they asked him, hey, do you have any guns? Oh, yeah, I got this 380 registered to me, this Bursa. Okay, we found the Bursa. Any other guns? No, no other guns. Lie. He never registered it either. This idea, well, I didn't know that I thought we didn't have to register handguns. Really? But when did the feds change that rule? I missed that on the national news. The other important piece of evidence here is investigators, DNA experts do not find Kevin Bloom's DNA profile on any one of those swabs. Not on the muzzle, not on the inside part of the barrel itself, and not on the grip and trace. His DNA profile is excluded. That means not there, not present, excluded. Let's talk a little bit about the Bletch crime scene for a moment. We know from the testimony of Detective Ferris that right around 6:02 p.m., we see inactivity. In other words, earbuds are being unplugged on Rebecca's phone. 6:02. And we also know from the evidence in this case that at 6:11, Michelle Clint's husband is calling 911. So we start with that time frame. 6:02, 6:11. But that time frame shortens up just a bit. Because if you remember, the Clints did not make that 911 phone call immediately upon discovering the body. If you recall her testimony, they live on Automobile Road, they're going south on Automobile, they get to that stop sign, or they get to the intersection of Riley Thompson Automobile, and Mrs. Clint tells you about seeing something on the side of the road. Wasn't sure, in fact, thought it was an animal at one point in time, wasn't sure what it was until they got a little bit closer. And it was her that got out of the car and had to inspect to see. She's a nurse by trade. And then the phone call happens. And we know when the Clints are making their way down Automobile to Riley Thompson, they don't see any cars or any vehicles. So the time frame of when Rebecca Bletch is killed is very, very short. I would suggest to you, the evidence suggests that it was shortly after those earbuds are taken out. We know from Mrs. Clint as well as first responders that when they find her, Rebecca is on her stomach, that her head is turned, that she's barely breathing. If you recall again that 911 phone call. The other interesting thing is that pile of stuff, the earbuds and the phone holder as well as the sunglasses are piled neatly across the street from where she was. We also know from investigators that they find a long rifle, .22 caliber shell casing in the middle of the roadway, CCI brand. And we know that they find two .22 long rifle shell casings on the side of the road very close to where her head was. Again, CCI brand. We know from Dr. Shattuck's testimony in the autopsy that the wounds discovered on her body were consistent with her falling forward. Okay? And that Rebecca suffered 3 gunshot wounds to the head. That the manner of death was homicide, and the cause of death was multiple gunshot wounds. Now I want to briefly talk about this McCormick gas station video, because I know the defense is they're itching to tell you about it, so let me tell you about it. And if you recall Larry Brooks' testimony, and you saw the photographs. You saw the contrast between that video image and the image from the Herringa investigation. Big difference. Mr. Brooks, again, 31 years, was able to tell you, yes, I'm convinced that is a Dodge Grand Caravan, but couldn't tell you the color. He says, I don't like color. Best I can do. The defendant gets on the stand and says, hey, not mine. One there. Not me. And maybe he's right. Maybe. The point of the testimony this morning from Sergeant Austin Amott was to show you, visually, show you the time it takes. We talk about direct routes, all right? And here you talk about Automobile Road, where Rebecca was, right around the 4300 block of Automobile Road. Defendant's house at 1842 South Sheridan. You can see the main artery really out of there is US 31. So how do you get to US 31? Well, you can do it one of two ways. You can go northbound, hit Riley Thompson, hit Russell, and then ultimately get you to 31. That takes you right past the McCormick's gas station. And if you recall from this morning, should be still fresh in your heads, going the speed limit, remember that, going the speed limit is a 14-minute drive. Or, to avoid any contact really, you go southbound to Bard to Russell, north on Russell to US 31. No gas stations there, no chance of being caught on video there. That, going the speed limit, is a 12-minute ride. So, let's take you back. Time frame. Rebecca's killed right around that 6:02 hour. Plenty of time, regardless of what route we took. Plenty of time to get home and make that phone call. Plenty of time. And again, Sergeant Amott didn't just kill somebody and wasn't fleeing for his life. Just imagine if those were the circumstances. How fast you might be going, how quickly you were going to get out of the area, how fast you were going to get home. And I'm sure as the defendant was driving home, his mind was racing. He figured, you know what? I got to do something. I got to establish a timeline somehow. So I'm gonna call my friend, this police officer, make a record of it. I'm gonna then get that record shortly after Rebecca's death, and I'm gonna put it in my digital trophy case. Just on the off chance. But I didn't do it. Lieutenant Crump, firearms expert with MSP, you folks, and I will admit to you, that was probably the first time I've ever done that in my career. You folks had the opportunity to actually see what Lieutenant Crump sees when he does an examination. You got a chance to see the shell casings, the test-fired shell casings, and the scene-collected shell casings and the matches, where they matched. You got a chance to see all the 3 bullet fragments that Lieutenant Crump had and the test-fired bullets and how he was able to show the match. You got to see that for yourself. And you heard his conclusion that the gun found in the defendant's possession in his van, the one with his DNA profile all over it, was the same gun that killed Rebecca Bletch. That, ladies and gentlemen, is the murder weapon. May 16th, 2016, the arrest of the defendant. And I don't want you to forget, because this is really important, I don't want you to forget the lengths and the time and the effort that law enforcement, what they did in order to get to that point. You heard all that testimony. A lot of agencies working together to get to that point. Ultimately, that leads to, as we talked about earlier, that leads to the photo lineup, that leads to MJ identifying the defendant, and ultimately leads to search warrants at the house as well as the van. And we know from the search warrants of the van, we know that there was a stain found on the cargo area of the floor, and there was a swab of that stain done, and we know that the defendant's DNA profile was 14 million times more likely to be a contributor. In other words, if you recall, this was Michelle Schmidt testifying to you folks about this new, improved, highly advanced system now that MSP labs are using, and its likelihood ratio. So his profile is 14 million times more likely to be a contributor to that stain than an unknown random individual. And according to their calculations, that is strong support that he is a contributor to that particular stain. We also know from the search of the van, this toolbox, right? This rape kit, as the evidence seems to suggest. And yesterday, we went through the note, if you recall the note that was crumpled up and found at 3038 Bailey. Almost like a little checklist, if you will, right? Of things to remember, like cameras, ball gags, zip ties. In some respects, as you look at that note, it almost appears to be a checklist for perhaps, maybe, the defendant's own movie. But some of the things in that list are contained in that toolbox. We know that the defendant's fingerprint is on the inside of the toolbox. We talked about the injection site map. And again, I emphasize this idea of access to insulin. And as Dr. Shattuck explained to you, what insulin does to a person. A non-diabetic person injected with insulin can do a lot of things. It can be make you groggy, to make you unconscious, to kill you. And as Shar told you, they had class about it, her and the defendant. They had class about this. We know that we find 2 video cameras. That in this car we find, or in this toolbox we find rope, we find chain, we find a J-hook, we find this lubricating jelly, which, if you recall from some of the paper evidence, Detective Ferris was able to track down via the defendant's credit card or Meyer card that it was purchased by the defendant's card. We have in this box 2 notes with women's names on it. One is handwritten, one is typewritten, and it's a typewritten one if you recall Sergeant Flowers' testimony about finding the defendant's fingerprint on that particular note. We also find this ball gag, and we know from the forensic testimony that the defendant's DNA profile is on that. And again, if you were randomly going to find somebody in the population with a similar profile, it's 1 in 50 sextillion. That's 21 zeros. We know from, I should say, let me back up here on these handcuffs. Oops. Handcuffs. The handcuffs, the interior, important, interior was swabbed. And we know from the forensic on that the defendant's DNA profile was a match, and that to find somebody random in the population with a similar profile would be 1 in 283 sextillion. Again, 21 zeros. We know that this leather restraints, that the swab was done on, again, the inside, the part that you would put on your wrists. And we find the defendant's DNA profile on that. Again, random search. It'd be 1 in 1.7 septillion. That's 24 zeros. We have, I should say, in the same picture, this Mizuno glove, the black glove Mizuno. A swab of the exterior, we find the defendant's DNA profile that matches the defendant. And again, a random sample, it would be 1 in 473 sextillion, 21 zeros to find a similar match. We have in a separate, if you recall, in the gun safe, which is right here on the left, in that separate gun safe, we find that pair of Adidas gloves. Again, a swab of the exterior, we find the defendant's DNA profile matching, and that it would be, again, a random sample would be 1 in 783 septillion, 24 zeros. We also find these items, the silver bullet sex toy and the purple dildo. And if you recall, the forensic folks swabbed the tip of that purple dildo for their analysis. And they found a mixture of 2 DNA profiles. If you remember, I believe it was Mr. Hayhurst initially found that mixture. And this was right, again, if you recall, along the times that they were making that transition from the old system to the new system. He transferred that all to Michelle Schmidt. And Michelle did her work and found that the defendant was 79 billion times more likely that he was a contributor to the mixture. 79 billion times more likely that his profile was a contributor to the mixture found from the end of the purple dildo. Very strong evidence that his DNA profile is part of that mixture. Important also, Ms. Schmidt finds that Rebecca Bletch is 4,600 times more likely to be a contributor to the mixture, which is strong support that she is a contributor. The other important piece that Ms. Schmidt told you as related to that piece of evidence is that she did not locate any foreign DNA. Essentially, she did not find any other profile on that item that either wasn't related to the defendant or Rebecca Bletch. The Reebok gloves. Again, swab of the exterior. Defendant was 47 million times more likely to be a contributor to the mixture, i.e. strong support that his profile is in that mixture. But really most importantly, ladies and gentlemen, and I want to preface this by saying, if you remember, David Hayhurst talked about examining these gloves, and if you recall, he talked about seeing some very small stains on the outside of these gloves. And if you recall, when he did his initial analysis, one test seemed to suggest the presence of human blood, and one test did not. And he explained to you the second test, he was concerned that the sample might be too small in order for that test to pick up. But when the swab was done, we found that Rebecca Bletch is 90 quadrillion times more likely to be a contributor, equaling strong support that Rebecca Bletch's DNA profile is in the mixture that is on those gloves, along with the defendant's. Those gloves inside the toolbox, inside the defendant's vein, along with the murder weapon. The other significant part of all that DNA work is that Kevin Bloom's DNA profile is excluded. Not that he's a part of any mixture. Excluded as a contributor. Excluded. And let's think about, again, the defendant's convenient defense story. If these were, in fact, Kevin Bloom's gloves that he used to play softball or whatever he did, wouldn't you expect, in the time frame that he had these gloves, that he would be leaving at least part of his profile on the exterior? Wouldn't common sense and reason suggest that if I own something, and I've owned it for a while, and I touch it all the time, and then I let somebody use it, and then I get it back, my profile should be on there in some way, whether it's as a major donor, as a minor donor, or as a single source. My profile should be there. And in all, not just those gloves, but the Adidas gloves and the Mizuno glove, his DNA profile was excluded, i.e. not present. The other part that really, why this Kevin Bloom defense defies logic and common sense and is not a defense, is that the defendant is with two detectives. He knows about the Rebecca Bletch homicide. He knows at this point that his cousin borrowed the gun in May, returned the gun in July. He has an opportunity talking to the police at that moment in time. And what does he do? He lies about his own possession of the gun. I want to take you back to the defendant's defense opening statement. All right? Jog your memories. Go back. Back in time. Do you remember that the defense promised you a few things? They promised you that you were going to see and hear testimony about this collusion between Kevin Bloom and Kevin Bletch. That there was going to be this idea of, we've got to kill Rebecca for the insurance money. Essentially, according to his opening statement, what he was going to show in his part of the case was Kevin Bloom and Kevin Bletch were in cahoots, and Bloom was the murder for hire. I hope you all recall that, because you didn't hear a single piece of evidence related to that. Not one. Not one. Why? Because it didn't happen. It doesn't exist. Ryan Hehouse, if you remember his testimony, the fact that he surveyed about 9,000 calls, right? Calls from Mr. Bloom, calls from Mr. Bletch, not a single link between the two of them. Not a single one. There is no connection. There is no evidence because it never happened. And you heard not only from detectives doing their work as far as the alibi is concerned for Mr. Bloom on 6/29/14, but you heard from Rhonda and Tori. He's at a soccer tournament in Grand Haven. The championship game starts at 5 p.m. They're not leaving the parking lot of where they had parked their cars. Because remember, this is important. They drove one car in because of the crowd. Left two cars out, one car in. Everybody goes in together, everybody leaves together. They're leaving Grand Haven around 6 o'clock. Rebecca Bletch is already being murdered. And we know, as Rhonda told you, I went directly to Little Caesars. We've got the receipt. 6:24, she's at Little Caesars. Gets home and Kevin's already home. Rebecca's already dead. There's no way, there's no logical, common sense way that Kevin Bloom gets to Automobile Road, kills Rebecca Bletch, and gets home. No way. Now, I suspect that defense will talk to you about the transcript that we had yesterday, the fact that Kevin said in that transcript that he touched the gun, but did you listen carefully when he touched the gun? He said, I touched that gun 3 or 4 weeks ago. His interview was June 2016. 3 or 4 weeks ago puts it at 2016. They'll, I'm sure, bring up the fact, well, he reset his phone, that he thought Rebecca was attractive, that he even looked her up on Facebook. That does not point to murder, ladies and gentlemen. No way. In particular, as we look at, again, he wasn't even there. He was driving home from Grand Haven. The interesting thing that Mr. Bloom says, and I hope you caught it when they were reciting the transcript yesterday, is he tells investigators, oh, hey, by the way, the defendant told me he shot her. And as we've indicated in the stipulation, one of the stipulated exhibits, that on April 26, 2013, the night that Jessica Herringa is being abducted at 11-ish, Mr. Bloom's working at the DOC. In fact, he just started a shift. He started a shift at 10. The other thing that I don't want you to forget when we talk about this element number one is Bubba and the silver van. And you heard from Detective Ferris, there was never any mention in the media, any mention by anybody about looking for a silver van. Yet the defendant says, no, Bubba, whoever Bubba is, whether he's real or not, said, hey, look, they're looking for a silver van. Now, of course he knows that, because he drove the silver van to Automobile Road, shot Rebecca Blanche, and he screamed home real quick to make that phone call. He knows that. He knows the silver van as well because he was in it. He did it. The evidence proves, ladies and gentlemen, beyond a reasonable doubt, that the defendant caused the death of Rebecca Bletch by shooting her with that P-22 found in the van. Element number one for both felony murder and for premeditated murder is met by the evidence beyond a reasonable doubt. Second element for premeditated and felony murder, so the second element for both, is that I have to prove that the defendant intended to kill Rebecca Bletch. And there are some guidelines, you'll hear these instructions, the court will read you, to help you determine a person's intent. Because we can't crack open somebody's head and look and see what they're thinking about, but we can look at things they do in order to help do that. For example, you can look at what he said, how he did it, or by any other facts and circumstances and evidence. In particular, in murder cases, you can also look at the kind of weapon used, the types of wounds inflicted, the acts and words of the defendant, and any other circumstance. So as we go back to the crime scene involving Miss Bletch, I've gone over, I think, pretty much ad nauseum, the defendant's connection to that P-22 handgun. That's crystal clear. But we do know that Rebecca was shot 3 times to the head. 3 times. And really, the only reason why you do that to a person, execution style as I like to call it, is you're intending to kill them. That's the only reason why you shoot somebody in the head. Your intent is not to maim, is not to hurt, is not to do great bodily harm, it's to kill. The evidence proves beyond a reasonable doubt that the defendant intended to kill Rebecca Bletch. The third element, so now they separate. So the first 2 elements are the same for both charges. The third element for premeditated murder is that the intent to kill was premeditated. That is, thought out beforehand. Okay? And the evidence that I want you to look at as you make that determination is, first and foremost, the digital evidence, the rape, torture, and kill videos. The cookbook, if you will, for the defendant. The fact that he carries a loaded, obliterated, serial numbered weapon, unregistered, in his car with easy access. The other fact of the matter being that he also carries with him not only the gun, but also the tools to incapacitate a victim. That insulin. So gun makes him not move and freeze, insulin knocks him out. I want you also to consider the fact that he had this little list, that rape kit note found on Bailey, his checklist. This wasn't a random act against Miss Bletch. This was well thought out. And he made sure he had the tools with him in order to essentially commit the crime. Yeah, I don't think, ladies and gentlemen, you could ignore 3038 Bailey, the abandoned house, the safe house, if you will, to take victims to. The fact that as you look at both Jessica Herringa and Rebecca Blatch, the mantra is no witnesses left behind, i.e., I'm not leaving anybody alive who can identify who I am. And again, I go back to the MGN situation. It is seriously by divine intervention that that young girl is still alive today. There's no question in my mind. The evidence supports not only that I proved this element, but the defendant had a plan for Miss Bletch. And if he couldn't accomplish it, if he couldn't pull off the abduction, she wasn't going to live to tell about it. The fourth element for premeditated murder is that the killing was deliberate. That the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been a real and substantial reflection for a long enough time to give a reasonable person a chance to think twice about the intent to kill. And as we talked about, I think in my opening, the law doesn't give any black and white rule. You have no guidelines here, folks. It's up to you to decide. It's as to the time required, it's up to you to decide if enough time has passed. That is your decision and your decision alone. So, I want you to go back, obviously, and think about the evidence that we've talked about already in the other elements, in particular the ones on intent to kill. And I want to walk through this. So, this photo, this was People's Exhibit number 1. And I put this here to give you a frame of reference. As you can notice, the weeds are pretty tall here, okay? And we know from this particular screenshot of a cruiser video, that's Miss Bletch on the ground. And if you remember, at this point, they had rolled her over to start doing CPR. That's why she's not on her stomach anymore. She is on her back. All right? So we start with that. We start with, again, from the autopsy report. In particular, the evidence supports this scenario. If you remember from the autopsy report, the first wound discovered by Dr. Shattuck was wound she called A-B. A being the entrance, B being the exit. And you recall from the crime scene here that we had one shell casing in the middle of the road. I suggest to you, ladies and gentlemen, that the evidence supports the fact that wound AB was the first shot Rebecca faced. Because if you look at the autopsy report, Dr. Shattuck describes the wound path as left to right, back to front, and upward. And if you remember, that bullet kind of penetrated but then skipped off to the side and exited. They did find some fragments between the skull and the scalp. But that was more of almost like a ricochet. In other words, the defendant pulls up on Rebecca Bletch, uses whatever ruse. I'm lost, whatever it is to get her to stop. Pulls the gun. Rebecca decides, no way, and fights to run. Defendant shoots. First shot, that's wound AB. Catches her in the back. If you remember, ladies and gentlemen, that as Dr. Shattuck explained, that wound itself was enough to knock her down. And we do know, as if you remember, that the injuries that she discovered were as if she had fallen forward, consistent with falling forward. You remember how the Clintons found her face down. So wound AB is that shell casing. She tries to run, gets shot, gets knocked down. And we also know that, from the crime scene, that the two circles represent, the first circle is where her head was, and then the second circle is when she was rolled over. And you can see placard number 5. And that's important because that's shell casing number 2. And I want you to pay very close attention, ladies and gentlemen, to how close shell casing number 2 is to her head. As well as shell casing number 6. You can still see the outer edge of the circle encircling that blood, and where shell casing, the second shell casing is. And as if you recall Brian Harrison's testimony, those two shell casings were relatively close to one another and were a short distance from that particular, the head mark. And we know from wound C, okay, the wound path is different than wound AB. Remember, AB went left-right. Wound C is right to left, back to front. And you remember the position of Rebecca's head. It was on her left ear. Wound D is again another right to left. And what is of particular importance to the doctor's description is without significant deviation up, down, front, or back. I.e., if you recall her testimony, straight across. Ladies and gentlemen, I suggest to you that, as I indicated, wound AB was the first shot. That's shell casing in the roadway because Rebecca's running. She gets knocked down. She's face down now, incapacitated, can't fight anymore. And then the 2 kill shots, C and D. And we know that they were not only close in succession to one another based on the position of the bullet holes on her head, but also positions of the shell casings themselves. And certainly, ladies and gentlemen, we don't know how long the defendant stood over her body while she suffered. But we do know, and the evidence strongly suggests, that the defendant could not have her alive. And unfortunately for investigators, because of the thickness of Rebecca's hair and the amount of blood in her head, they were unable to gather any gunpowder residue or stick blood. Because as the doctor told you, her hair and the blood would have soaked it up. And that's important, ladies and gentlemen, because that helps us determine distance. But we have other evidence to help us with that, the shell casings themselves. There is absolutely no question that the evidence supports this idea that he had time to think about whether this was a good idea or a bad idea. Think about the pros and cons before he did that, before he pulled the trigger 2 and 3. Absolutely had the time. He had the time to walk over to where her body was. He had the time to contemplate, and then he had the time to think and shoot twice in her head. That third shot, wound D, again, that's a temple. That's execution style, ladies and gentlemen. The fifth element of premeditated murder is that killing was not justified or excused, and obviously there is no question that Miss Bledge did anything. She did not do anything to deserve to be shot to death. There's no question about that. That's premeditated murder. Let's switch over to felony murder. The third element of felony murder. When the defendant did the act that caused the death of Rebecca Bletch, the defendant was attempting to commit the crime of kidnapping. And the judge will read you the instruction on what attempt means, that the defendant intended to commit the crime, that he took some action toward committing that crime, but failed to complete it. The action must go beyond mere preparation to the point that the crime would have been completed if it had not been interrupted by outside circumstances. And again, you're allowed, as we talked about this, MRE, 404B, other acts, you're allowed to use other acts evidence, i.e. Jessica Harrington's case and MJN's case, to help determine whether the defendant was attempting to kidnap Rebecca Bletch. So I have to show and prove that he attempted to forcibly confine or imprison Rebecca Bletch against her will. Well, if you look at, again, the circumstances surrounding Jessica Herringa being forcefully abducted from her place of employment, if you look at the circumstances surrounding MJN, essentially being rused into the vehicle and then held at gunpoint. Both ladies were alone. There was a gun involved. And clearly, as MJN talked about, the defendant wasn't slowing that car down. He wasn't letting her get out. So we know with Rebecca's case that she was alone in a rural area, that a gun was produced, that the explanation for the pile of her things only suggests that the gun was pointed at her and she was told to take those things off. And why? Phones these days have that great GPS tracking. I mean, why else would you make her take off that phone except that you didn't want to be tracked or have her be tracked? But for Rebecca trying to get away, but for that fact, the defendant would have completed that crime. He would have confined her against her will. The second element of kidnapping is that the defendant did not have the legal authority to confine Rebecca. Well, again, we've got a gun involved, and Rebecca was an adult woman. He had no authority to confine her. Zero. The third element of kidnapping, that while he was attempting to confine Rebecca, the defendant attempted to forcibly move or cause Rebecca to be moved from one place to another for the purpose of kidnapping or to murder or to take as hostage. Well, the evidence that helps support that particular element, I go back to the digital evidence first, the kidnap, torture, kill videos. I go back to 3038 Bailey, the fact that the defendant was the one that padlocked those doors, that nobody was living in the house at the time, that this was a house to be used for this purpose. You've got the rape kit note, his checklist, if you will, of things and items that he needed. You have the evidence that we've gone over of the Jessica Herringa abduction. She was taken, more likely than not, to be used as a sex item and then killed. MJN, again, the purpose was to forcibly move her from one place to another, and certainly keep her, or to kidnap her, keep her as hostage, probably treat her the same way that Jessica Herringa was treated, and certainly the way that he wanted to treat Rebecca Bletch. The fact that we have a handgun involved, Rebecca moving against her will. And in all three cases, all three women were essentially alone. The fourth element of kidnapping is that the defendant intended to kidnap or confine. Well, again, you can't break into somebody's head and look at what they're thinking, but look at the circumstances of what was done, how it was done, and the facts and circumstances surrounding it. And you look at this particular case, the fact that a gun was produced in order to essentially force Rebecca Bletch to do the defendant's bidding. Again, you look at the Herringa and MGN cases as to the intent of the defendant, helping you decide what the intent of the defendant was in this particular case. The intent, clearly, I think the evidence supports, was he was intending to kidnap her, take her to Bailey, do whatever he wanted to do with her, and then kill her. And as you look at it, as you evaluate all the three different scenarios, that part, the intent to kidnap, was the first step in the common scam plan and system in the defendant's act. First step was the intent to kidnap or confine. The fifth element of kidnapping is that the defendant acted willfully and maliciously, that he knew it was wrong to confine Rebecca Bletch and knew he did not have legal authority to do so. Well, again, I don't want to sound like a broken record, but I want you to think about the fact that there was a gun, that we waited until she was isolated, the removal of her things from her person that ultimately would make her whereabouts known. All those things indicate that he was acting in a willful and malicious way and knew that it was wrong to try and confine her. Because why else would you use a gun? There's no other reason. The fourth element, and now we're back to felony murder, is that the killing was not justified or excused. Again, there is no question that Miss Fletch did anything to deserve to be shot to death. Nothing. There is no justification. There is no excuse. The second count is felony firearm. The first element of that is that the defendant committed the crime of murder. We've gone over that quite a bit. I'm not going to rehash all that. I've already showed you that the evidence is there to prove that beyond a reasonable doubt. Second, that at the time he committed the crime, he knowingly carried a gun. Well, we know that the handgun in the possession of the defendant when he was arrested matches both forensically on a DNA level as well as a ballistics level as being the murder weapon. We know that that the defendant himself admitted that he carries that gun around with him when he's in his van. So there's no question, including the crime scene, the shell casings and the bullets, that at the time the defendant committed the crime of murder, he knowingly carried a gun to help him commit that crime. As my last and parting thoughts, ladies and gentlemen, I know I've been standing a long time. You guys have been very patient. You've listened very carefully, and I appreciate that. But I hope you can appreciate, because of the fact that we have so much evidence in this case, there's so much to go over and to tie now to the elements, that we had to spend some time to do it. But again, I thank you for your service. I thank you for being the jurors in this case and for sitting intently, patiently, and absorbing this all. I know it's been a long road, but at the end of the day, ladies and gentlemen, at the end of the day, I'm asking that you find the defendant guilty of premeditated first-degree murder and or first-degree felony. The evidence supports the finding beyond a reasonable doubt that the defendant is guilty of both those crimes, as well as the crime of felony.